We will plan on holding these elections in July. The formal hearing that we had scheduled for this morning has been continued until the July meeting. Also, in your folders, you will have there are new forms for you to sign authorizing Karen to sign documents for you. This will be used primarily for payroll and travel claims. Please sign those and return them to Karen. And then finally, Stan, I'd like to recognize Stan's service to this board and to the state and to the practitioners for his 9 years of service. He's ineligible to be reappointed, so Stan, your leadership will be sorely missed on the board, and I get the pleasure of working with Stan back in Memphis, but hopefully here you won't be a stranger to everybody that's here. I think Mark has a presentation for you.
We have something for you. Of Accountancy 2004 to 2013 in grateful appreciation for service to the board, to the public, and to the CPA profession.
Board members and fellow CPAs, it's been wonderful the past 9 years to be able to be of service to the state of Tennessee in this role. I've learned a lot. I hope I've contributed quite a bit along the way as well. And I will miss coming to these meetings, wink. But 9 years is a long time, and I've really enjoyed working with everyone. So I'm not so long. I guess I'm the oldest member on the board now that's leaving. And I wish everyone all the, well, I want to say luck, all of the wisdom to carry out the role of the state in this capacity. Thank you.
If you'll look in your packet, you should have a copy of the minutes from the last board meeting. If everybody would please review those, and I'll accept a motion to accept the minutes.
So moved.
Second.
A motion and a proper second. All those in favor, or any discussion? Sorry. Having no discussion, all those in favor signify by saying aye. Aye. Motion passes. Mark, you want to go ahead and start with your Executive Director report?
Well, you have it in front of you, and I believe it was emailed to you earlier, so you should have had time to read it. I do want to emphasize a couple of things here, and a couple of things that I did not mention. First of all, I would like to encourage you all to consider attendance at the Naspa Eastern Regional Meeting. This will be in Chicago, June the 26th to the 28th. This is a great way to meet your compatriots from across the country. The networking is invaluable. The information that you glean is very valuable. Those of you that have been to meetings, I think, would say that. So please, we are budgeted to take the Executive Director and 3 board members to this meeting. So if you are available and willing to go, I'd certainly appreciate you letting me know that so we can get the travel authorizations in and get the approvals started. I did want to let you know also that the PEAK, the Professional Ethics Executive Committee for the AICPA, has requested an exposure draft on the new AICPA Code of Professional Conduct. Comments are due by August 15th, 2013. So what I'm going to do is I'm going to try to review this, get some comments together for you to review. If you'd like to review the entire thing, I'll certainly be glad to send it to you. But otherwise, I will draft the comments and have them for you to review at the July meeting. I did note in my Executive Director's report that Mr. Mills was going to appear before the Arkansas Board at their April the 26th meeting, providing expert witness testimony in the case for them. I will say the case went extremely well. The Executive Director was very pleased with what Mr. Mills did, and I'd like to recognize him at this time for the outstanding job that he did on that particular case. And Don, if there's anything that you'd like to add in regard to your testimony or your trip to Arkansas, feel free.
I don't really have anything. Appreciate y'all letting me go. It was a good opportunity to kind of cross state lines and see how other boards work. A lot of similarities there. some differences, but I think board members are.
The only thing I'd say is, of course, you all know that we are moving. Today is move date, so as soon as we leave here, the staff will be going back and finishing packing up, getting ready for the office to be moved this afternoon. They're moving us at 3:30. Computers and telephones are being turned off at 2 o'clock, is my understanding. So we should be incommunicado for the rest of the afternoon after that. And that's my report, Mr. Chairman.
Thank you, Mark. Let's move right into the board committee reports. Troy, Law and Rules Committee.
Well, the Law and Rules Committee, we did not have anything to discuss, so we did not meet yesterday, so I have no issues to report.
Jennifer? I'm sorry, the Licensing Committee?
Yes, the Licensing Committee met yesterday, and we had 3 items on our agenda, and we have a motion for the board. I'll just put everything together in one, and then you can vote in the end. The first was a request from Summer Buchanan for extension of the exam window. I'll give you a little bit of background. I'll be brief. She passed the, is it FAR? FAR. Do I say FAR?
FAR.
The FAR. Sorry, I'm not an accountant. She passed the FAR section and then was hospitalized due to a severe lung infection. And that led to 2 hospitalizations, 2 surgeries, partial removal of the lung 2 times, had subsequent pain issues. Actually, subsequent to the surgery, she was able to pass the auditing section, but then had some complications with developing long-term pain and problems, and has asked for an extension for just 1 exam window. The rule that we look to on that is 0020-01-.066C that says that we can grant an extension if it's lost by reason of circumstances beyond the candidate's control. And the committee yesterday, after reviewing the medical records that we were given and the applicants or the request, the candidate's request, and talking about it, decided to recommend to the board that we give that 1 extension of the testing window. The next was a request from Connor Lowry for extension of the period for completing the 150-hour educational requirement. As a reminder, candidates can start sitting for the CPA exam, and then they have 200 days to complete the 150 educational requirement. And Mr. Lowry completed the educational requirement a little longer. It took him a little short period of time over the 200 days to complete that. And in his letter, he explained that the reason for that was because he got married, he took a job with PricewaterhouseCoopers, was traveling, had the busy season. He then was delayed getting his 3 extra hours and was doing it online and could only submit so many requirements within so many days, and that led to the extension. The rule for that, actually it's a statutory, we had to look at the statute, TCA 62-1-106C1, that says, upon written request and for good cause shown at the board's discretion, the board may extend the period for completion of the educational requirements. We debated and discussed, and the committee recommends that this is not good cause shown, that basically it sounds like life. If we were to grant this, it would do away with the rule, because any applicant that could be foreseen to request this always is going to have deadlines, and I think a quote was proper prior planning prevents poor performance. We discussed. So we're recommending that this extension not be granted. So the last one was a review. It was a review of the request from Brad Dickens for reinstatement of a revoked license. And my understanding is Mr. Dickens is here before the board today. We were just given the request, the 1-page application, and we didn't have any other information. The rule that we look to this as 0020-01-.10. That's page 37 of the rule book, and under section 4, it outlines what the board should consider, to be able to question, what were the circumstances, what he's done in the past. And since he wasn't there for us and we didn't have any further information, we recommend deferring that to let the board question Mr. Dickens here today. And that concludes my report.
I guess we need some motions here to, or do you have to, we have to vote on the, on all those issues?
Let's take the first two and vote on them.
Right, separately. Okay, so do I have a motion on the recommendation from the licensing committee?
I'd make that motion that we approve the licensing committee's report.
Second.
Is that specific enough?
Will do.
Okay, I have a proper motion, I have a proper second. Any discussion on the first two? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Okay, the ayes have it. The last issue is the reinstatement of the license. How do we want to go about this? Mark, do you want to give us kind of an overview? And
Certainly.
then,
In the October 27, 28, 2005 legal case report, this is what was presented to the board and caused the revocation of the license. The complaint alleges that respondent CPA embezzled more than $140,000 from a corporate client. A third-party accounting firm performed an investigation audit of that company's books and determined that respondent had in fact misappropriated money from the company. Company has since sought and obtained reimbursement of those monies from its insurer. The insurance carrier apparently has advised the company not to pursue criminal action, believing the misappropriated money can best be recouped from respondent if he is allowed to earn money. There are no criminal or civil charges placed as far as I know. Mr. Dickens signed a voluntary revocation in order to close the complaint. So he is here for you to examine at your will.
past the 5-year.
Yes. This was in 2005, so it's been 8 years, 7.5.
Go ahead and open this up for discussion.
Restitution been made.
Mr. Dickens, do you mind stepping up here, please, or sitting? I'm sorry, right over here at the podium.
I went down. They took everything I had in my bank account, and the insurance company actually contacted me in February or March or April of 2005, and apparently an affidavit had been signed from the company that they received no property, money, or anything from me. I showed where they took all of my money that I had at the time, and a signed affidavit where they swore they took nothing from me, and the insurance company said, okay. Kind of my contention on the front end, I didn't, actually Mr. Crocker was the investigator. To begin with, but as far as restitution, he's actually one of the owners of the company, and he feels like I owe him. I just want to get my life back. At the time, there's just no way I could fight this. I didn't have the means. Be like way too much against me to even try to fight it, and I didn't have much of a choice but to voluntarily revocate. I didn't have any means to fight it. but all I want is to get my life back, to support my family, and I will never put myself in a situation around people or in any situation that would compromise my name or my license again. Technically, Mr. Crocker came out to my job site in October, I believe, of '05, but this really kind of went down in '04, so it's been pretty much 9 years for me that I've had to deal with this.
What type of work have you been doing since that time, since the revocation?
Well, I did construction for quite a while, and then I did. My dad owned a construction company, and I worked for him for a number of years. My dad wound up having a stroke, and it paralyzed him on the right side of his body, and it got to a point where he couldn't work anymore, and that's just been last year and a half or so. I've tried sales. I'm just not a salesman. I just couldn't do it. I've tried recruiting, IT. I've done a number of different things, but accountant, and I think I'm a good man. That's where I want to be, to get back, just basically to get my life back and support my family.
How many years had you been practicing before this incident occurred?
Graduated college in '94. I took this job, I was 27 years old. Obviously, now that I'm 41, there's a lot of things that are different, not only in the way I think, but just everything around me. But I passed the, are you wanting to know when I graduated college or passed the exam?
Wondered how many years have you been practicing in the accounting profession before, I guess, 2004 or 5, whenever the incident occurred.
I think I passed the exam in '98, 96 or '98, but I think it was '98, and I went to work for them in 2000.
So your experience was always with the same firm that this incident involved?
Bulk of it, yes.
During your 8 years, I guess, since the incident, have you had any intersection with the accounting profession? Have you?
But one thing, when I got the application from Mr. Crocker, and I saw, I had to have 80 hours in a 6-month time period, I have went to work. It's technically not a CPA firm, but it just doesn't name itself in that. They know that my license is revoked. I mean, obviously, she's a CPA, and she looked it up online and saw that, and we talked about it, and it's basically just a matter of, if this goes okay today, I stay, and if it doesn't, then I'm out.
To speak on your behalf, or?
He was one of the owners of the company that accused me of this to begin with, and it was his contention was basically the same as mine. It was just at the time, I just didn't. When they took everything I had, not every attorney practices in front of a professional board. And I talked to a number of different attorneys, but it was hard to find one, first of all, that didn't have ties to them. And then the money, after I lost everything, I just didn't have it.
They took everything. Who is the they that you're?
The company
The company. Okay.
took everything. And to be honest, I haven't even seen all the stuff. There's a few things that the investigator, asked me about, and I was like, take for instance, one of them was stealing insurance. I didn't steal any insurance. I had my wisdom teeth cut out. I did all this stuff. I paid it out of my pocket. If I was going to steal insurance, I would have used it, or I would have tried to, pay for it out of my pocket and go to the insurance company to get reimbursed. But I didn't have an insurance card. I didn't have the insurance. Another thing that was brought up was I was paying myself more than what the salary was supposed to be that was given to me. I didn't even have control over that, and he can even, as one of the owners, can tell you that there was 2 or 3 people that would have went through, and if I was going to do anything, the last thing I would have done would have been try to push it through on a payroll check. But I just didn't have a way to fight it at the time.
How did the company take everything? I mean, did they have some take your assets? I'm a little confused how that happened.
Basically, I was called into a room, and they told me to play ball or I'd never see my kids again. And they asked me how much I had, and they said, we're not going to go after your license or livelihood, but we've got to do something to get some money in here. And they asked me how much I had, and I said, I think at the time I had $25,076 and some change in a savings account. And they said, that'll do.
So you voluntarily turned it over to them? Is that what you're testifying?
Sir.
Balance of the money was provided to the company by their insurance company?
They collected everything without taking into account they got 25 out of me.
They or the insurance company aren't looking for any restitution from you? The company isn't?
I can't remember now after so long, but it was one of their people from Illinois called me and came down here, and I gave them a copy of the affidavit where they signed that they collected nothing from me, and a copy of the pink slip where $25,000 from me to them came out of my account. I was told even then, always keep this in a safe box, and I still have it.
Representative of the company where you took the money, is he prepared to?
Good morning, everyone. My name is Tony Lanier. At the time this went down, I was 25% owner. Actually, it was 24.7%, I think it was. There were 4 equal partners. There was 1% still left owing to the previous owners we were purchasing the business from. I began work with this company in 1981. We had gone through multiple periods of a buyout process, and there was always an issue. We had to start over. Finally, it was consummated in 2005. Brad came on board as our replacement accountant there sometime in 2000, about mid-2000. Brad was young. He was naive about certain things. I had no reason at all. Let me back up. I currently do not have any ownership in the company. In April of 2006, even with my tenure there, I'd spent my life there. I don't know how much detail you want to get into. I just want so kind of paint the picture for you. I elected to file for a divorce, and my wife was making it very miserable for me. And as a result of that, my 3 partners decided they didn't want me around anymore. It was less expensive for them to oust me. I left from there with nearly 30 years of my life dedicated to that company. I walked away with nothing but a tax return prepared from these same people owing the federal government $987,000 because of the explanation that I got. And you got to understand, I was devastated. This was my life. The reasoning that I had for that was because you were no longer liable for potential losses. In hindsight now, looking back, it wasn't right. It was a ploy to force me to sign the documents to get out of there. I was going through the divorce. My wife was making life miserable for me. By the way, we reconciled and got everything back together. And if all that wasn't enough, I had decided to build a nearly $1 million home during the same period of time, which I was financing out of my pocket. So there I'm stuck. Don't own my business, don't have a job, and now I've got this big house I've got to finish, but miraculously it got done. I knew Brad. I got to know Brad during this period of time. We rode motorcycles together. I do not have all of the details of exactly what went on, and that was intentional. There were only 2 individuals there, the people we were purchasing the company from and our elected president. The things that I do know that had taken place that Brad was being accused of, I knew was false. All of this didn't really come out until after Brad had left, and then shortly after that is when my problems started with him. He was being accused of taking money from the company via credit card purchases. The credit card purchases they were talking about were things that Brad was paying on his credit card. Internet access, for instance, that was one. That was a regular bill. They had to have a credit card. The company did not have company-issued credit cards, so Brad stepped up and used his credit card for the payment every month. And then he would reimburse himself for those payments. Perfectly legitimate. Honestly, I cannot tell you why Brad was put in the situation he was in. I honestly do not know. I don't know. The way that we bought this business, we were running 2 companies simultaneously. One of them was incorporated, one of them was an LLC. So there was constant shifting of dollars back and forth. We had just come off of 2 very good years, and we were in a slump. I'm speculating, and I'm trying not to speculate because, again, if I don't have the facts, I don't want to allude to something that I don't know to be factual. I know that there were some, for accounting in the construction industry, your bonding company is what gets you the work, and obviously your bank statement and your bonding company need to be kind of coincide with one another in order to get the work. Our net worth was dropping along about that period of time, and this was shortly after we had physically taken ownership of the company, and that's when this started. The only thing that I know for a fact is that the credit card purchases that he was accused of were false. They were absolutely false. There was another gentleman in the company, bless his heart, he's gone to be with the Lord now. He was doing some of the same things. Some of our vendors would allow you to pay them with a credit card. Well, we allowed him to do that so that he could build enough points on his credit card he got him a trip to Hawaii. It was just the same situation. So, do I feel like Brad Dickens stole money from me while I was there and me owning 25% of that company? Absolutely not. Absolutely not. Do I still consider Brad a friend? Absolutely, or I wouldn't be standing here. Do I have anything to gain from this? Nothing. that's about all I can offer unless someone's got a question they want to ask me specifically.
I have a question. Did you make these same statements back when the investigation was occurring?
I was never involved with the investigation. Everything, when I knew that this whole thing had gone down, I took care of the computer systems in there along with multiple other things. Right, in accounting software. I didn't know the accounting software, but I was responsible for the updates, that sort of thing. I came in one morning and I was asked by the gentleman we were purchasing the company for that stayed on a retainer under contract with us to disconnect Brad's computer, freeze the access to the servers, and bring the computer to him. That's when I found out about it. By that time, all the wheels had been in motion already. After everything was said and done, I was told that he had been accused of stealing money. I didn't have all the details. Some of the stuff he's mentioned this morning is the first I've heard of it. The one thing that I was aware of was the credit cards. I said part of this, again, like the paying the internet access every month on his credit card, I knew that. I knew that was going on every single time. The rest of this stuff, I didn't know. I just knew that we were doing a similar situation with another individual in the building, allowing him to pay for some of this stuff to gain the points on his credit card. I hope that answered your question.
Actually, when I was told...
Can you step to the microphone, please?
I was told not to take it outside the room, and even I may have already been gone before...
Step up to the mic, please.
It wasn't frozen. All that had not been done. They actually asked me if I would work another year for them, and I said, "Hey, I can do that." So then they asked me if I would just work through the first quarter, and I just really didn't want to. I just didn't know what would happen, so I agreed to work to January 31st, and on Friday, January 7th of that year, I had shoulder surgery earlier in 2004, and I had a blood clot develop, and I wound up going to the emergency room. The clot had came up to the right side of my lung, so I wound up in the hospital. January 15th and 31st and so forth, but I was told to not speak with the other partners when this went down, and he specifically told me he didn't want this to be a deal where certain people are on my side and certain people are on his side, but short of getting the ownership of this company by an amount of money, and that's exactly what they accused me of.
Did you take money from the company?
I did not take anything from the company that wasn't completely knowing. Looking back, were we all kind of loose and free? Times were really pretty good at the time. We were all probably loose and free, and that's one of the things that's I think a lot different about at 41 than I did in my late 20s. But it wasn't that I took money that someone didn't know about. There was a lot of things going on, such as people who never left their home getting large travel allowances. People were having things paid off, and should they have sent me a W-2 with a little extra income on it? Maybe so, but as far as just willfully deceiving and taking something that was not mine, No. As a matter of fact, some of the things that were on my credit card that he was talking about were monthly recurring bills that by the time I got out of the hospital, I had paid some of their expenses long after I was gone, before I realized, as some of them they wouldn't let me, since I no longer work for the company, they wouldn't let me take it off my own credit card. So I had to cancel the credit card just to and get a new credit card just to get it off my bill.
Specifically, what things were you talking about that you, when you said you got a little loose with it? What type of things?
Well,
for
we
example?
all, they would, at the time, and you got to remember this was a construction company. They would do things for you, write you a reimbursement check, or they would do things that, I guess if you really got down to the letter of the law, maybe it should have went on a W-2, some car allowance and things of that nature. But we all got vehicle allowance, but it didn't necessarily go on everybody's W-2 and get taxed for it. That was probably the loosest. Now, I didn't receive a living allowance or any of that stuff, but that was it was just a little bit better economic time.
Were you in charge of preparing the W-2s for all employees?
No. As a matter of fact, the first part of the time I was there, we had an old system that serviced anymore, and they had to bring an outsider in to do all of that. It didn't do W.
What exactly was your role then?
I was, I guess, technically the controller, CFO there.
Someone direct you to write yourself checks? I assume you wrote them, or directed that they be written for these travel allowances that you were or were not entitled to, even though everybody else was doing it?
I never got travel allowances.
I think that would be helpful if you. I know it's been a while, but if you could give us some specific, what were the majority of the monies that you received? What were they for?
Credit card reimbursement.
It was all credit cards. So what were the charges on the credit card exactly?
Well, we had a guy in South Carolina that needed a $35,000 piece of equipment, and he called me one day and said, "I've got to have this today," and you knew about this. He said, "I have to have this today, but we only allowed $3,000 in the petty cash accounts." He said, so he'll take a company check, just not, he knows this one is not going to clear. I said, the only thing I can do is overnight you a check, FedEx, and you get it tomorrow. He said, that's not going to help me. He said, we've got to have this today. And so I gave him my credit card, and they put it on my credit card. And then the company reimbursed me.
Now, is that part of what you're saying that they said you took?
Yes.
When you say the company reimbursed you, was someone else reimbursing you, or did you reimburse yourself?
Well, it was just sometimes they would write me a check, and sometimes they would just pay my bill directly, pay it directly to American Express. Or
who is they? I mean,
the owners. He was, authorized.
Who wrote the check is the question. Did you direct that the check be written to reimburse you?
No. I had to fill out a form. To get the reimbursement.
So all of the reimbursements that they're saying you stole, they or misappropriated, whatever, someone else signed off on?
Yes. Every one of them. And I actually had a file folder in my desk. And sometimes, in corporate, you get a little behind on your CPE. And it was December, and I had to have 48 hours of CPE before 12/31 to have my 80 for that 2 years. And since I didn't have time during the year, we were running 2 separate companies. I scheduled a Monday through Friday that in December, and then I had to schedule a Monday of the next week. And then he and I were together that weekend, and he said, "I'll see you Monday." I said, "No, you won't see me till Tuesday." And then Tuesday, the lady who wrote all the checks, she had gotten in bad health and she died. And then about 15 minutes later, that's when
Did I understand you to say that the insurance company reimbursed the company? So the insurance company must have felt like there was something wrong. I mean, insurance companies don't just let go of their money without.
that I can't answer. But when they contacted me, they dropped it, and that's been over. I don't know what their thinking was on that.
You currently have any kind of judgment against you from the insurance company? I know it was mentioned that at one time they said it was better than to have you working and paying them back. Did you ever have to make a reimbursement to them, or if you continue to work, you don't owe them anything?
I'd like to ask a question. Mark, did we get a chance to look at, or did you get a chance to look at the CPA firm that investigated this, to look at their report?
No, Henry, I don't believe we did. Once Mr. Dickens signed the voluntary revocation, we closed the case.
Mr. Dickens, did you ever look at the report that the CPA firm did? Did they get a chance to look at it? Nobody did. They're the ones that concluded that there was a misappropriation of funds.
Yes, sir. And they're the ones that sent the report to the insurance company.
Were they hired by the insurance company or hired by the company that was embezzled?
For that, I don't know.
They were hired by the company.
They were?
Yes, sir. And part of what they got paid was actually on the insurance.
Reimbursed by the insurance company?
Mark, what is management's recommendation regarding this?
Management's recommendation would be that since there's no outstanding judgment and Mr. Dickens has gone 7.5 years without his license, we'd recommend that you give it back to him with a probationary period, perhaps of 2 years.
Ask a couple more questions. Shift your focus. Currently, you said you were working with a lady. I think you said, is she a CPA and she has a CPA firm? Is she a?
Well, what it is her partner is not a CPA, so they can't call it a firm. It's a corporate. It's a little, but it acts just like a CPA firm.
What kind of work does she do, or does the
just
firm do?
taxes and bookkeeping?
And I think you've testified that if you were to get your license reinstated, that would be where you would be fully employed?
Yes. Hopefully. You
would be doing bookkeeping type work and doing
taxes.
What kind of shifting your life? I mean, can you tell me a little bit about what you've been doing in 8 years, like personally, professionally, to the community? I mean, have you been involved with any organizations, professionally or personally, or?
Organizations, not really, other than always before this and during this, and then to this day, I've been very active in my church. I do the music at our church. I've done the music at our church for, gosh, probably close to 20 years. Every Sunday, And Wednesday night, my wife is over the preschool at the church. So basically, when I wasn't, working, most of our things are kind of centered around our church. And I don't want that to sound like, the guy that just went to prison and found God. I found God before this, and He'll be with me after this. But that's another thing is probably my kids. My son is not old enough to compete, but we got special permission. As an 8 and 9-year-old, he made the state finals of the Geography B, and he actually won the state and the southeastern region of the United States in the History B, and he's going to the national finals on June 1st. So it's pretty much work, church, kids, wife.
Another question, Mark. Did we do, or have y'all done a judgment or lien search against Mr. Dickens? I mean, do we know for certain that there's nothing outstanding?
No, Gabe, we have not.
Mr. Dickens, did you sign a release or anything with the insurance company back when y'all kind of settled this matter and you gave him the $25,000?
I didn't give it to the insurance company.
I'm sorry, the company.
Yes, I think we did, because they told me we're not going after your livelihood or your license. We just need the money.
End up signing anything with the insurance company, like a release? I know you said you had these affidavits, but did you sign a release?
I didn't sign it. The company signed those.
Okay.
Other discussion, questions?
You see your pink slip? I won't tear it up or anything. How do we?
I'd like to ask one question. Who filed the complaint?
Actually, I guess I really don't know.
My recollection, it was a former board member, Henry, who actually brought the complaint to us.
So the four owners of the company are not the one that filed the complaint. It was the ones they were purchasing the business from.
Legally.
Chairman, would you accept a motion?
I would. I'd like to say one thing, and I think Mr. Roberts has a good point on these searches, and I feel that any motion that we make should be contingent upon some of these searches. I would hate for us to make a vote to reinstate someone's license and find out later that we hadn't done our due diligence as we should. So that's a very good point. I will entertain a motion at this point on the reinstatement of the license.
I'd like to make a motion that we reinstate the license of our individual here, subject to the due diligence work, as you referred to, Mr. Roberts, and if you...
judgment and lien search, I guess, and Mr. Whitaker, I'm sure that, but I'm happy to assist to the extent that we need to.
And with the 2-year probationary period, and obviously to get that, he'd have to have the CPE brought up to date according to the standards.
All good with that motion?
I'll second that motion.
Okay, I have a second. Any discussion? Hearing none, all those in favor of the motion signify by saying aye.
Aye.
Ayes have it, the motion passes. Your license is reinstated subject to the provisions of
I have one question.
the motion.
I know there are no judgment or liens from that insurance company that, but my credit has taken a hit in these last 9 years, and I got behind on some credit cards, but it has nothing to do with that. That's not what you're going to be looking for, is it?
No, it would be a search of the public records at the Secretary of State's office and maybe in some county offices. I'm not sure back then what would have happened. But it's looking for outstanding judgments from a court,
I just had
creditors, or any
just
type
had
of
that
liens
done,
that are placed on your assets from those type of.
3 weeks ago to get the job that I've got now, so I feel confident that that's.
Okay. Yeah, it's not a. I guess it's not a credit report or check or anything like that.
As far as probation, how does that work? I can't put CPA on a business card for 2 years, or?
Can use the term CPA, Brad. It just means that the board is watching you very closely.
And also, since this will be a reinstatement with probation, I will be drafting an agreed order for reinstatement with the probationary condition. So that'll be something that Mr. Dickens needs to sign, and then once we have those signatures, we'll need to get a signature page to the chairman for his signature as well.
Thank you, Mr. Dickens.
Thank you.
I would like to step back here for a minute. I think I inadvertently passed over. Are there any Naspa committee reports, Board Effectiveness and Legislative Support Committee? Jennifer?
I can give a brief. The NASPA Board Effectiveness and Legislative Support Committee met here in Nashville on February 13th. And they're finishing up, this is a new committee. It's changed a little bit. It's finishing up the work that was done by the previous committee. And basically, a lot of information was gathered about, trying to figure out how boards are made up and what makes them effective. And they took the data and they're analyzing the data to try to figure out components of effectiveness and independence and, what you need to do. And really, where they're trying to go is coming up with tools for boards to be able to self-evaluate, to say, here's how we're doing in the terms of being effective, and here's how we can maybe improve. So that's where they're ultimately getting towards. We discussed things like, they never want it to be where boards are being judged against other boards. It's really just would be a way of this board being able to say, okay, we're doing well in these areas, like, we're doing well in enforcement, we're doing well in CPE, but we're weak in another area, and here's some ways maybe that we can look to strengthen. But they're also looking at some public record, like how do it be so that it's public, but if it doesn't need to be public for the whole world, or just how to communicate this information. So that's what they're looking into. That's their next phases. And also what's happened is, and you've probably gotten some emails about this, there's the NASPA State Legislative Tracking System. It's a software. We got a preview of how they set it up and how they've flagged terms to just kind of go out there with the databases and see all the legislation that's been introduced that could actually impact our regulatory function, or any state's board's regulatory function in the profession. And if you go to this website, there's a map, and there's color coordinated. So like Tennessee could be color, I think the color's green, and it would mean there's potentially some significant legislation that's been introduced that can impact the accounting profession and maybe how this board regulates. And it would give you the bill numbers and a summary, and then you could take it out and go do your homework and actually see if maybe it's legislation that's going to change how this board is set up, or, powers of the board, or that affect actually the accounting profession. And then this board could actually take that information and go use it. I think that the deal is to try to, ensure that boards have what they need to act on behalf of and to protect the public. And also, to help, everything's about effectiveness, to help this board be effective and enhance our ability to be effective, or all boards, all state boards. And also, I think they're looking for some collaboration to allow boards, with that map, you could see other boards that have had similar situations going on legislatively where you could collaborate and share experiences, and boards be more effective by having a dialogue. So that was launched this winter. I think an email was sent out just recently, maybe yesterday. And hopefully that'll be a tool that this board can help during the next legislative session to monitor what's going on.
Thank you. Troy?
The former Accountancy Act Committee, we had a conference call in March, and at this point what they're trying to do is to redefine the word attest. And what has happened, we had a task force that proposed a change, and the change removed the word assurance from part of the how it was defined. And so there was a problem at this point. Somebody had brought up with that word being removed that the definition of report would have to be changed. So that became an issue when they redefined a test. Then it would redefine how a report is defined. And so at that point, they appointed three folks to go back and try to redefine the test, the word attest, and what that meant to where it would not affect the other words. In other words, is what they're trying to do. And I think they're probably going to decide on that this month at this point. But the other issues are still in progress. They're still trying to. They're going to work on inactive CPA issues is still there. They have not completed that, and they're trying to see how this may relate to compile things. And at this point, that is the three things they're trying to work on. I think we'll probably have another call here in about two weeks to decide how that goes. So that is what they're working on.
Thank you.
Sure.
I'll move into the executive committee report. Yesterday we met and discussed just really a couple of issues. There wasn't much on the agenda. The main issue being the issuance of comfort letters to the banks. The executive committee's recommendation was that we not get involved in anything like that. We feel like the standards address the way to provide attest services, and we do not need to be in the business of setting new standards. So, did I say that correctly? Okay. But we can have any discussion that this board would like to, if they wish to, on that particular subject. I assume there's nothing we have to do, Mark. Just we don't do anything currently. So it was just a topic, and Mark had actually given us an example from U.S. Bank of something they were looking for. And I'll just read a small excerpt here. It says, a letter from a CPA explaining that the impact of the withdrawal of the funds will not impact negatively the ongoing viability of the business. So that was not something the executive committee felt was something we wanted to step down on that avenue. So any commentary as it relates to comfort letters? Okay. We reviewed the budget yesterday. We are projecting a surplus by year end. And so that we went over. And then we also met with Commissioner Giannini. He came in and basically gave us an update on appointments and things like that. So we had, in our discussions, we felt like it was probably a positive thing to postpone the elections of officers till July until the governor has a chance to appoint his appointees and allow the people that will be serving on that board for the next year to actually vote for the officers. I think last year we did a little bit early and some of the officers, or one of the officers for sure, just did not get reappointed, and so we had to go through the whole process again. So I think as a matter of policy, it might be a good idea just to wait until those appointments are made, so as to not cause confusion to the board. So that is all I have. Any commentary? Hearing none. Mr. Royston, do you want to go ahead and go into probable cause?
Yes, let's go into probable cause. Mr. Whitaker, have you got the revised reports to publish?
Mr. Royston, I do have the revised reports to distribute, and I will do that. But while I'm doing so, Mr. Joseph will be back to do his litigation report very shortly. So while I'm passing those out, if we could have Mr. Mills do his complaint status report, and then have Mr. Joseph present, so he can head on back to the other building, and then it's just a different order.
Joseph, would you
here right now.
present? I just want to give you the floor. Yes, sir.
Morning, members.
We understood we wanted to get rid of you in a hurry, so go ahead.
Yeah, so we can get back to packing our boxes. I have a matter before you today. This is a supplemental legal report on a formal proceeding that I have. As the board is aware, this respondent was indicted in January of 2011 for bankruptcy fraud and related offenses involving his own personal bankruptcy that he filed in the Southern District of California in 2005. Specifically, what he pled guilty to was that he knowingly and fraudulently concealed an asset of his bankruptcy estate, which were his, or was his, offshore account in the Channel Islands, in the amount of $156,000. None of these funds were client funds. Served 9 months in the Middle District of Tennessee before he went back to the Southern District of California for sentencing. He was sentenced in October of 2011, and he was sentenced to time served, a $100 assessment, and 3 years of supervised release by the U.S. District Court in the Southern District of California. The respondent is currently residing here in Nashville under the terms of his supervised release. His supervised release is scheduled to expire in October of 2014. The board previously approved a proposed settlement offer to the respondent sometimes, I do believe, in the summer of 2012, which would have revoked his CPA and his firm licenses until October of 2014, for which he was then eligible to petition for reinstatement. Of course, that would not require the board to grant same, but that would just simply be a minimum period of time. He didn't accept that consent order at the time it was offered by Mr. Whitaker. However, after we filed the notice of hearing and charges, the respondent did agree. He did sign an agreed final order in which he has agreed that his CPA and his firm permits are revoked. From this point forward, if the board were to agree for a 2-year period, and that he would not be eligible to apply for reinstatement of his CPA and firm permits until May of 2015. He would also have to provide evidence to us that the United States Probation Office has terminated his term of supervised release, and that he successfully completed it, and that he's paid to the state the assessed investigatory and hearing costs that we've incurred in this matter in the amount of $200. To the extent that the respondent did not take client funds to the extent that he has been convicted of the offense. He served a federal sentence. We've had no problems with him, nor has the U.S. Probation Office had any problems since he's returned here to Nashville. We were of the opinion that the period of revocation of 2 years was adequate, and had he accepted the agreed order or the consent order that the board approved in the summer of 2012, he would have ended up doing about the same amount of time insofar as a revocation period had he signed that agreed order, maybe a couple of months more. But based on what this respondent did compared to some of the other serious cases involving federal convictions that we've seen where client funds have been taken, we thought that a 2-year revocation period as set forth in this agreed order was an appropriate penalty. And the respondent would also be required that after the 2-year period, if he desires to petition for reinstatement, he would have to personally come before this board at a future board meeting as a
Thank you,
would
Mr.
recommend.
Joseph.
Yes, ma'am.
Are there any questions for Mr. Joseph regarding this? Our committee yesterday made makes the recommendation to the board that we accept this. We've already gone through the details of it. This is an updated agreed upon order or updated set of standards, and it really extends the date by a little over almost a year. So it was our recommendation that we approve this one.
Separate vote on this, I presume. Full board vote, yes. Okay, do I have a motion?
Move.
Second.
Okay, a motion and a second. Any discussion? All those in favor of accepting the plea signify by saying aye.
Aye.
Ayes have it.
Thank you.
Thank you, Mr. Joseph.
Mr. Joseph, how old is this individual?
I don't know. I've spoken with him on the phone. I assume he's probably got to be my age, mid-50s or so. He's indicated to me that he's worked previously for the state of Tennessee for more than 20 to 25 years. So I would assume at least in his mid-50s.
Thank you. Be sure and pack the coffee pot.
Thank you.
Mr. Mills, would you like to make your reports to us on the status of the accounts that we have now, status of the cases?
Yes, sir. I think you have my status report in your packet. It's fairly self-explanatory. No real surprises this quarter. You've got a year history included in those. You will note that overall our formal hearing, our formal charge authorizations have dropped. That's due to actually getting them closed, getting some action taken on those. Mr. Whitaker's appears to be rather large this month. That's only because he's getting ready to drop 32 today on your desk. So I think we're in pretty good shape. Questions, I'd be glad to try and answer them.
Thank you, Mr. Mills. Do you have anything else you'd like to report from your area as investigator that just bring before the board?
Good, thank you.
Okay. Thank you. Mr. Whitaker has given you a report, and these have been changed for our updates from yesterday. If the members that were not on the committee yesterday or whatever, people would take a moment and read through them. There are quite a few of them. There's 32. Point out a few things to you. 3 and 4 are not exactly the same, but they're the same people. One is, number 3 is actually for the individual. Number 4 is for the firm. So they, while related, are different.
Which was one that we amended? What number was that? Do you remember?
7, Mr. Eldridge.
27.
Number 27.
I have a question about number 6. Apparently, this individual has paid a civil penalty for the same offense in 2010, and we are assessing $7,500. But for this particular offense, it seems to me that maybe this individual doing what he's doing is profiting pretty good if he's able to pay $5,000, and I don't know that $7,500 is going to be large enough to deter it. That's my only question. Because he paid $5,000, she or whoever the respondent, I guess, paid a $5,000 penalty, and they continue to do the same thing. So, just food for thought on the civil penalty itself.
Mr. Sawyer, this is not an individual. It's an entity. So that's who the respondent is. And Mr. Mills investigated this. He may be better to address the size of the company and how much profit they may or may not be making from operating without a firm permit. So if Mr. Mills has any feedback, I'll be...
I would say that the respondent firm is fairly successful. They seem to be doing quite well. In their defense, this was a totally different concept of practicing without a license than the first violation. It's not exactly a repeat, but again, it still comes under the same law and rules. So, feel free. I think that, this is not a struggling firm. They'd be all right.
We turned them over to for criminal action, practicing without a license, since this is a repeat. At our course of action, sometimes when we have people who are non-licensees who continue to be a problem to this board.
Alexander, give me one moment to look at the law book.
While Mr. Whitaker is looking it up, I guess, I don't know, maybe the penalty ought to at least be doubled from the last one, just from 5 to 10 rather than 7,500, to send a message. It's not an oversight, correct? It was not an oversight, the respondent.
Not in my opinion, no.
Okay.
Mr. Whitaker's looking that up. 11 through 17 deal with privilege license cases. You'll see a lot of Texas and Alabama in here. Those are where they have finally, in the past, you'll remember from our other meetings, they have sent a lot of non-compliance renewals out to other state boards where people moved out of Texas. And I believe Mr. Whitaker yesterday used the word cattle call, where they'll take like 300 cases and handle them at that point at a time, and then just send letters out. So those are not as important as I would think as these.
Yes, sir. I guess one of the things I pointed out yesterday was it seems like there were several instances where an investigation could have been avoided, and we wouldn't have to use our resources and time to go and investigate something that really was not, didn't have merit to it, if that's the right way I understand it. And as we kind of discussed this, I think that what we determined there was a need to improve communications between us and Department of Revenue. If they've got the updated information on a person who's when the late charge is filed, or whatever the right terminology is, that they're 2 years delinquent, and then by the time when we get to the investigation, they've paid it, but we don't have access to know that. I mean, my concern was we're wasting our time and limited resources to go out and investigate these claims. So I just wanted to kind of throw it out for discussion. Would it be prudent, or would it be beneficial to us to have some sort of task force? I know when I say this, I'll get appointed to it, so I tread carefully to it. And I don't know if it needs a task force, but maybe just a charge that we make an effort to reach out to them and try to work out the communication issues to improve it. I mean, at the end of the day, we're all on the same team. Goal is to get protect our industry, but also collect for them to get the taxes that are owed on our licenses, or for our licensees. So, does anyone else agree with that? Or I just think, I don't know if it may be just to Mark to reach out to them, or we can as a committee, or we can ask our commissioner to meet with their commissioner. I don't know what the best way to do it. It just seems like we would be a lot more efficient if we could improve the communication between us. And
one of the things that came out yesterday in your discussion too was that we could refer this to rulemaking committee and let them come up with a rule for our next batch that goes through, that we would have some teeth in it, because we're actually collecting a revenue debt. But if we have this in our rules, that it's something that makes it easier for us to have some civil penalties that come back to us if they don't pay their fees, and make it a part of it to where, at least if we're going to have to do it, then we're covered. And I think that may have been the solution we came up with yesterday, that we've got a problem, and getting the computers to talk is not going to work right now anyway. If we could look at it, I think it's a tremendous idea. So, Mark, was that your recollection yesterday on?
Yes, the professional privilege tax rulemaking was what I had written down. Develop a rule that makes the professional privilege tax a matter for civil penalties, because right now we're assessing it under discreditable acts. So yes, if we can pin it down and recoup some of our money, I think that's the best way to go.
I could punt this to the lawmaking committee, and then I don't have to deal with the task force that I'd get appointed to.
So they could bring you in as an expert witness.
Don, are you saying that if somebody owes a privilege tax and they're behind on it, and the Department of Revenue sends us over notification of that say they owe the Department of Revenue $200, then we could tack on another $200 as a penalty for collecting that?
Yes.
I think if I remember correctly, what the situation was, and y'all correct me if I'm not remembering this correctly, but as I think I said earlier, is the person gets 2 years behind. I guess once they get 2 years behind, then I guess it comes to us to be investigated for where we revoke their license. Is that the law?
Mark, tell us about the letters, if you will, because that's what really I used get out of jail free card yesterday as a term, but.
Okay, the way it works is if you're behind 1 year, the statute provides that you get a letter from the Commissioner of Revenue. If you're behind 2 years, then you're sent to your appropriate board or commission for possible suspension of your license. If you're behind 3 years, that's basis for revocation of a license. That's what they ask that we do. When we get a list, the first thing we do is go through and call out the ones that are only 1 year behind. We get with the Department of Revenue and get as much information as we can up front from them, so we are not wasting our time bothering the people who are only 1 year behind, who are really not going to fall into our bailiwick. We do send out a first letter. I send out a first letter of request for information and letting them know they're behind and what's going to happen if they don't pay it. If they don't get to give us notification that they have paid their professional privilege tax, then I send a second letter stating, by the way, next time you hear from us, it's going to be a complaint because we are required to do this by law. And then before we open the complaints, we ensure that they are still 2 years behind according to Department of Revenue records before we open the complaint.
You open that complaint, and they pay it after you've opened the complaint. When they usually will pay it as soon as the complaint is open, and then we're in this category here of doing nothing with them.
Exactly.
And that's what we were discussing yesterday is not right.
And Mr. Royston, just to kind of further draw out and expound on what Mr. Crocker was saying, with a specific rule that states failure to timely pay under our law and rules, because the Department of Revenue statute is an entirely different statute from ours. But with that rule, then even if we have situations like we have here where we can confirm that as of the time the complaint was opened, somebody was 2 privilege tax periods or more behind, even if they pay it after opening the complaint, there could still be grounds for the assessment of the civil penalty to recoup some of our administrative and or investigative costs. You know, it's not necessarily called collection, but, you know, to make sure that the board is not losing money or wasting resources only to find themselves at the conclusion of an investigation with no legal leg to stand on to impose any kind of penalties. And so that's where we're heading once that rule change is done, which, as we all know, could take a while. But
thank you. While we're on that discussion, can we entertain a motion to refer this at this point to the rulemaking committee to handle this situation so that it doesn't get lost and then it's our committee would like to make the motion that we turn this to rulemaking committee so that we can put this in a formal rule change in the next batch that goes through.
Okay. I have a motion from the Rules Committee. I mean, from the, excuse me, the Probable Cause Committee. Do I have a second?
I'll second.
Okay. Any discussion?
I just want to make sure they had a committee meeting the next time we meet. So that was
just gave them something.
I know.
All those in favor signify by saying aye.
Aye.
Okay, passes.
before we go back to the report, if I can answer Mr. Alexander's question, looks like the board essentially has two legal options to attempt to deal with persistent repeat offenders for unlicensed conduct. On page 16, you have TCA 62-1-112, injunctions and restraining orders. And without reading all the text, basically if the board believes that someone, it says, engaged in any acts or practices that constitute a violation of this chapter. So in theory, I guess the board could go after a licensee in Chancery Court, but that doesn't usually happen because since they have a license, we deal with them here. But for non-licensees, it says the board may make application to the appropriate court in Davidson County or in the county which the acts occurred or alleged to have occurred for an order enjoining those acts or practices. This particular entity is in East Tennessee, is it not, Mr. Mills?
That's correct.
Okay. So if that were the board's prerogative, then probably have to be Chancery Court over in the county where that's taking place. The other option says criminal prosecution by Attorney General and reporter. TCA 62-1-114, page 18, subsection B, any person or firm who knowingly violates 62-1-113, which lists of prior prohibited activities, and it's on the prior page. Most of what's covered in 113 is unlicensed conduct, but it says that anyone who knowingly violates that commits a Class C misdemeanor. The problem that we've experienced before is that a Class C misdemeanor is the equivalent of a seatbelt ticket, essentially. I mean, maximum, I think it's $50 or 30 days in jail or something, and the few DA's offices to whom we have referred complaints previously, while not expressly saying so, have between the lines communicated that it's not even worth it to generate the paper, because even if they could get a conviction, who knows how much it would help.
I would think that when we issue this particular fine penalty, that they obviously don't know our rules, so they don't know what a Class C, whatever. I would just say that, charges will be filed in that judgment again against them. I think I would just put the language in that if this happens again, that we will file criminal, whatever you call it.
The language would be something to the effect of, will be referred to the appropriate criminal authorities for potential prosecution.
Correct.
The likelihood that these folks are going to know what that means, slim and none, but if between that and a higher fine gets them to comply, then that's great.
Or both. We discussed a higher fine yesterday, and I'm really not sure why we backed off of it, but this is the board, and we can certainly change the recommendation.
Did the committee agree on $7,500?
We discussed it and left it alone, although $10,000 was discussed yesterday.
It was
a long day yesterday with 32 cases to go over and read and all that.
Are we limited in some way as to how much we do charge as a civil penalty?
No, sir. Not within a range, no.
The way the civil penalty part of the law and rules reads is $0 to $1,000 per violation per day. So it's because it appears that this was an ongoing course of conduct. Mendon, if I'm misstating, please let me know. But at least in my opinion, the engagement and representation of the one client that we do have evidence that they did some work for did not all happen on one day. They didn't meet in the morning, do an engagement letter by lunch, and produce all the documents by dinner. I mean, that just didn't happen. So I think it's a reasonable case to be made, although at a formal, who knows, could go differently. But at least for purposes of a consent order, I think it's legally defensible to offer a $10,000 civil penalty.
That's what I would move. In addition to that, the language that Mr. Alexander asked about and Mr. Watkins suggested.
Chairman of the committee, I would second that.
Question. Mr. Whitaker, just to make sure I'm right, we have the option of criminal or the injunction in Chancery Court. Is that right?
It appears so, although I don't see any language that says it couldn't be both and instead of either or.
Just maybe in the letter we include that option as well. We've got not only criminal, but you also got the injunction, right? I don't know if that... I just don't want to limit us. I don't want us to go in and say that here's the fine. If we see it again, we're going to criminal options. When we find out maybe next year that it would be more of an incentive if we, file for an injunction. Jennifer, I don't know, you may have a better view on that than I do.
Well, the language could be amended to the effect that the board reserves the right to pursue any and all civil and criminal penalties allowable by law. That way it leaves you open for both.
Yeah, I like that.
That's your motion.
Do we want to vote on this individually, or do you want us to accept the entire report with the modification?
Well, since we're talking about this one, we can go ahead and vote on this one now.
Okay. All right. I have a proper motion to accept the changes for the language and for the $10,000 penalty. Do I have a second?
I seconded it.
Okay. You said.
I made the
I
motion.
second. He made the motion.
I'm
I
sorry,
second.
Stan made the motion.
And I accept the friendly amendment.
Okay. I have a proper motion. I have a proper second. Any discussion? All those in favor signify by saying aye.
Aye.
The ayes have it. Done.
Reading on down through the list, does anybody have any questions on any of the others? We amended number 27. Include a civil penalty of $500, which is in your new letter, primarily because our statute says that we are that you're required to, and you shall be sanctioned. And a letter of warning we didn't think was strong enough, so there was a $500 penalty put on that for just destroying your records as soon as the client's gone. And we're supposed to maintain our records for 5 years, and that's clearly spelled out. So that one was added.
Also added the proof of 5 years of the policy.
Exactly. I'm sorry, I missed that. And also the proof to send in a copy of their policy stating that they have a firm policy for that. So. And beyond that, the committee recommends approval of the sanctions and dispositions of the particular cases as presented.
Second by Mr. Alexander. Any discussion? Hearing none, all in favor of accepting the report signify by saying aye.
Aye.
Ayes have it.
Mr. Whitaker, thank you. I would request that in the future, and I know it's a running game trying to get the cases as up to date, but we would like to have a published copy of this prior to showing up so that we can read them and save some time on committee days and the others. And if we have to say this has been settled or changed, then we can do that, but it takes a long time to read and think about these and give proper consideration to them.
Mr. Royston, I have no problem with that, and I typically try to get that done. And the thing that I bump up against sometimes is the 180-day deadline that we have as established by the department to get these cases in, and with this board only meeting quarterly, for my other programs, typically I'll set a cutoff date of the Friday before the meeting, and I don't accept any new cases for the legal report. However, with this particular board, I mean, it's not so bad for, between the May and July meeting, but particularly, when you go from the end of January to the 1st of May, or the end of October until the end of January, that's quite a good number of days. And one of the requirements in my job description is to have a certain percentage of those cases referred for legal action. So with this one, I would say I probably had almost a dozen cases that the reports were able to be completed within the last couple of days before committee. And so whereas the legal report might have only contained 20 items, we got it up to 32, and better compliance with that performance measure means more pleasant conversations for Mark and I when we meet with Mr. Giannini and my bosses.
We have no problem with you adding cases when we come in and correcting for any changes, but we would prefer to have them ahead of time.
Okay, so
as much as you can
provide prior to the committee meetings, it would be appreciated if you could provide a report as to, if it's the Friday before, whatever you feel is appropriate for a cutoff, then just as a matter of fact, if something were to change or be added, just that would be the next series of numbers down.
Okay, that I think that's appropriate because I typically have to send a draft report to Mark the Friday before because that's one of the other policies that they have. So whenever that happens, once Mark's had a chance to look at it, we can just have it emailed out to the committee members.
I just think nobody wants to look at those cases cold is the issue. So
understood.
That completes our report, sir.
Thank you, Mr. Royston. Any old business?
I do have one thing.
Yes.
Chairman, since the last meeting when I volunteered to be on the peer review committee interview panel, I've accepted a different job with the state of Tennessee, and my time ability during the day is limited significantly, and I'm not sure that I can fulfill that duty faithfully. And I apologize for that, but it was kind of unforeseen at the last time. So I bring this up only to say that to the extent these meetings need to be done during the business hours of the week, I might need to step back from that volunteer position.
Mr. Crocker.
Do we have another volunteer? Mr. Blofus is serving on that committee. Currently, we have only one resume that's come in so far, but we do need 2 board members and myself to serve on that committee.
To the extent that it can happen after 4:35 or on weekends, obviously, I'm still happy to do it.
All right, thank you.
Alexander.
All right, then. I think that takes care of it.
Okay. Any new business?
One more thing under old business,
Okay.
Mr. Chairman. I've asked Mr. Whitaker to give us an update on the Osborne appeal.
Thank you, Mark. Members of the board will recall last July we had a formal hearing in the matter of Mr. Edwin Osborne. Came before the board on a second offense for noncompliance with licensure requirements. At the conclusion of the formal hearing, this board voted to revoke Mr. Osborne's CPA license and firm permit and to assess a $4,000 civil penalty. Mr. Osborne waited until the last day before the deadline to file his Chancery Court appeal, but he did file one, and that matter has been working its way through the Attorney General's office and the Chancery Court process. That is still ongoing. Mr. Osborne filed his appeal brief maybe a week or two ago, and as I understand it, for these kind of cases in Chancery Court, there will not be any witnesses, and it will be decided almost exclusively on the briefs. So the Attorney General's office attorney who's been assigned this case, I think he has 2 or 3 more weeks to file the AG's response brief, and then once that happens, it'll be up to the Chancellor to decide when the timeline is to make a ruling, and so that's kind of where it is. Something that's a little bit different, according to the AG's attorney, Mr. Osborne has copied the Department of Justice on his Chancery Court appeal. Something about Title VI and anti-discrimination, but based on my limited knowledge and review of Title VI, I'm not even sure how it would apply to a state regulatory agency matter. But
is this the gentleman that appeared and defended himself?
Yes, sir.
Took excessive amount of time? Okay.
Yes.
He was a lawyer, I believe, as well.
Mr. Osborne is not a lawyer, but he is.
Okay.
He was licensed as a CPA in multiple states. He also does insurance and some other things, and so that's kind of where we are. I think I'll be talking to the AG's office attorney in probably the next 30 days. He'll have some questions for me about the case when it comes time to put together his brief, and then after that we're at the Chancellor's pleasure. So that's the update, and if there are any questions, I'll be happy to take them, but otherwise that's our report on Mr. Osborne.
Any new business?
There's one item, Mr. Chairman, we have to review and pass a regulatory flexibility analysis in regard to the rulemaking hearing. Mr. Whitaker has that ready for you.
Okay.
Thank you, Mark. The board may recall especially some of the members who've been here a while. Part of the rulemaking process is something called a regulatory flexibility analysis. It's basically a brief analysis anytime new rules are made to determine impact on small businesses and other things of that nature. Prior practice had been to have the regulatory flexibility analysis done in with the paperwork, and as part of the rulemaking hearing itself, the board to vote on it, and then to go where it needs to go, back to the Secretary of State and AG's office and what have you. there have been some changes in processes and procedures coming down from the top of the department over the last 6 months or so. And one of those was a reinterpretation of an existing AG's opinion, and it was my boss's opinion that the regulatory flexibility analysis should be done before the actual rulemaking hearing was held. And so that's why we're having this vote today and not a rulemaking hearing today. So as soon as I read this into the record, all I will need is a board vote to approve it. And it's my understanding that once that is done, notice of rulemaking hearing is ready to go, already has been signed off on by the governor's office, and hopefully there won't be any further roadblocks and we can do this in July. So with that, I'd like to read the analysis and then request a board vote. The Regulatory Flexibility Act, codified at TCA 45401, and as part of the rulemaking process pursuant to TCA 45202A3 and 45203A, states that all agencies shall review all proposed rules and the effect that the proposed rule has on small businesses. The Act requires that each agency shall employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small business. I won't go through the description of the proposed rules because that's already on the record and in the minutes from the January meeting. And there is a list of factors to be considered, and they are as follows. Number one, will the proposed rules overlap, duplicate, or conflict with any other federal, state, and or local government rules? The answer to that question, in my opinion, is no. Are the rules clear, concise, and unambiguous? The analysis is that the rules are clear in purpose and intended execution. The implementation of these proposed rule changes will increase clarity and conciseness and decrease ambiguity in the rules as a whole. Factor number three, flexible compliance and or reporting requirements for small businesses. The proposed rule changes have no impact on small businesses, so there are no issues regarding additional compliance and reporting requirements. Number four, friendly schedules and or deadlines for compliance and or reporting requirements. The answer is the same as number four, because there are no impact on small businesses, no issues regarding compliance and or reporting. Number five, consolidation or simplification of compliance or reporting requirements. There are no new compliance and or reporting requirements as a result of this amendment. Number six, performance standards for small businesses. There are no performance standards for small businesses as a result of this amendment. And finally, number seven, do these rules erect barriers or cause other effects which stifle entrepreneurial activity, curb innovation, or increase costs? The board's determination is that these amendments do not place any undue burden on individuals or small businesses. If anything, the proposed reduction in the licensing fee for individual CPAs should make it easier for CPAs for the practice of accounting in Tennessee. Mr. Chairman, that concludes the regulatory flexibility analysis for the proposed rules for the, hopefully, July 2013 rulemaking hearing. And at this time, I would entertain any questions, and if there are no questions, request that the board vote to approve this analysis and move forward with the rulemaking hearing in July.
I have a motion to approve the analysis.
So moved.
Second. I have a second. Any discussion? Hearing none, all those in favor of accepting the analysis signify by saying aye.
Aye.
Ayes have it. Other issues? Mr. Whitaker, just as a point of order, our meeting starts at 8:30. Everybody was here on time this morning. I would appreciate timeliness in the future. We had to postpone the start of the meeting, just as a point of order there. Service. With that, we're adjourned. Or do I have to have a motion?
No.
No.
Invoice, you need to invoice too.